Hey everybody, John Skiba here from the Consumer Warrior YouTube channel. And in this video, I'm going to share with you the 4 steps of defending a debt collection lawsuit. Sometimes I think that helps to get just a big picture of what it is that you're dealing with so that you know how a case proceeds from each stage to each stage as you lead towards a trial. But if this is your first time here to my YouTube channel, please go ahead, click subscribe, check on that little bell. That way you'll be notified each and every day when we put out new videos that'll help you deal with serious debt issues. All right, let's talk about the debt collection lawsuit process. If you've recently found yourself being served with a debt collection lawsuit, you always go to the worst place and you think of all the horrible things that are going to happen. You think you're going to go to jail and all that kind of stuff. I can jump to the end and tell you there's no jail involved. These are civil lawsuits, but there is a process that they go through, and I find that it relieves a lot of anxiety if you understand really what each of the different stages of the debt collection lawsuit process are and different ways that you can try to resolve it. We're going to focus on 4 of those stages as it goes from the day the lawsuit is filed until you actually have a trial date where the court will determine whether there's liability on your end or not. Okay, so let's talk about the first step. So initially, the debt collector, the plaintiff in your case, they will file their lawsuit with the court. Once they file it with the court, they then are required to serve a copy of the complaint and the summons to you. Now, in most states, and in Arizona specifically where I work, they have to serve you personally, where someone literally comes by your house and drops off a copy of the complaint and the summons, and it gives you a chance to review it and see what the allegations are. The summons will usually tell you specifically how many days you have to file a written answer with the court. Now, in Arizona, again, where I practice law, it's a 20-day time period. You have 20 calendar days from the day they drop it off at your house, file a written response to those specific allegations in the complaint. If you don't do that, you're going to end up with a default judgment against you, where the court will just give them everything they're asking for and likely add on interest and attorney's fees and court costs and make everything a lot worse. So the first step is vital to file some sort of answer with the court so that you don't end up with a default judgment. Now, I can tell you nationally, 95% of consumers who are sued with a debt collection lawsuit end up with a default judgment because they don't respond timely or they don't respond at all. So it's important to take action as soon as you receive that. Look at the summons, see what the amount of days that you have to respond in your jurisdiction is, and then respond accordingly. Okay, so once that stage 1 is filing your answer. Once you have the answer filed, then the case proceeds into what we call a disclosure or a discovery period of the case. Now, the idea behind this is there can be no real surprises when it comes to trial. You know, the old Perry Mason shows where they would bring out some document or some bit of evidence and surprise them in trial, and that would win the whole thing. That's not how it works in the civil court case. Frankly, in the criminal court cases, it doesn't work that way either. The parties are required to disclose any information that they have, documents, evidence, witnesses, their claims, defenses, all that kind of stuff has to be disclosed well in advance of trial. And if you're in the state of Arizona where I practice law, you have 30 days from the day you file your answer to provide what's called a disclosure statement. Both parties have to exchange this document with each other. It's not filed with the court. And this is where you lay out their claims, your defenses, any documents, like I said, witnesses, that kind of thing. Now, this is often the first time in a debt collection lawsuit you're going to see all the documents that the plaintiff has. You're going to see, if it's a junk debt buyer, you're going to see the documents that are saying transfer the account to them. You're going to see monthly statements. You know, usually you get some big thick thing in the mail that shows, you know, at least what their evidence that they're going to use at trial. Now, it's important to note that if they don't disclose it, documents or evidence to you, they can't use it against you in trial. And it's also vice versa as well. If you have information or documents that you want to use at trial, you've got to disclose it. This is an ongoing responsibility. So even if, 30 days after the answer is filed, you provide your disclosure statement, and then 2 months down the road, you gain additional documents or information, you still have to do a supplemental disclosure at that point. The parties can also enter into what's called written discovery. Written discovery falls really into 3 different types. There are written interrogatories, written requests for production, and written requests for admissions. These are essentially where you're asking questions or you're asking documents, you put them in a formal request and send it over to the other side, and they have a set amount of time to respond to it. Now, one trick, this is kind of a little pro tip here. One trick that debt collection firms will often do is they will send you requests for admissions. Now, requests for admissions are just simple yes or no questions. They'll say, admit that you owe this debt. Admit or deny. Admit that me, Mr. Junk Debt Buyer, is the owner of your debt. Admit or deny. So pretty basic stuff to respond to, But there's a little trick in most of the states' rules of civil procedure, and that is if you don't respond timely to the request for admission, the court can deem those admitted. So sometimes you'll see debt collection firms will just throw out requests for admissions, knowing that a lot of consumers who are representing themselves are not going to respond timely, and then they will try to use that against you either in a trial or in a motion for summary judgment because it will have been deemed admitted. So you got to be real careful with that if you receive requests for admissions, of making sure you read the document, see what your response time is. It's usually similar, 20 to 30 days, but read in there, it'll have it in there. And then you need to make sure you submit that to the other side timely. Again, discovery is not filed with the court, but this is something that's just done directly between the parties. So the second stage was disclosure or discovery. And that jumps us into the third stage, which we see in pretty much every single debt collection case, which is a motion for summary judgment. Motions for summary judgment are filed if one party believes essentially that, hey, the facts aren't in dispute, we just need you, judge, to take a look at the evidence and tell us who wins. The debt collector is essentially telling the court, we don't even think we need a trial. We think you just need to look at our documents and then tell us that we are the prevailing party. Now, they do this for a couple reasons. One, most debt collection firms have very few attorneys compared to the amount of cases they have. They don't want to do a trial in every single case, and so they'll submit a motion for summary judgment as a way to avoid trial. Also, it's a way that a lot of people really struggle on their own to submit a response to summary judgment. It's much different than filing an answer. When you file an answer to the complaint, you're really just admitting or denying the allegations. A motion for summary judgment, you have a set amount of time, usually 30 days, to respond, and respond substantively as far as providing the legal defenses that you have to the specific allegations of the debt collector. So if you get a motion for summary judgment, if you don't have an attorney, that's a good time to talk to an attorney. I also have my Consumer Warrior tutorials and templates. I'll put a link down below. Those can help with that as well. The main thing that you have to point out in responding to a motion for summary judgment is you have to show the court that there are factual disputes that the court or a jury needs to decide at a trial. It's not just a legal question that the judge needs to decide, but it's something where we actually need to have the motion for summary judgment denied and press the matter forward to a trial type setting where these factual disputes can be resolved. So that's the third step, is the motion for summary judgment. If you're in a debt collection case, almost without exception, you're going to get hit with the motion for summary judgment because they know this is, in many cases, where they're able to get judgment against the consumer. Now, the fourth and final one is trial. Trial is, this is the big show. This is where you're here. This is where what you've been working for. And depending on your jurisdiction, this can happen relatively quickly. I've heard of certain states where in civil cases, particularly small claims cases, 60 to 90 days after the time the complaint's filed, you might get a trial date. I can tell you in Arizona, where I practice, if you're in the justice court system, which deals with cases under $10,000, you're not going to get a trial date for likely 8 to 12 months after the case is filed. If you're in the superior court, where it's more than $10,000 is in dispute, it could be anywhere from 12 to 24 months before you're going to actually get a trial date. So it takes quite a bit of time. The trial is, like I said, it's rare. In Arizona, the statistics are in civil cases, less than 2% of civil cases actually go to trial. But if it's a small claims type thing, that may go to trial more often than a larger amount. But if you go to trial, that's when you have to case. That's when the plaintiff has to be able to present their evidence. The plaintiff bears the burden of proof. They have to prove their elements. You don't have to disprove anything. They have to prove the elements of their case, and you'll have an opportunity to cross-examine, provide any rebuttal evidence that you may have to show either that they're not owners of the debt, that you don't owe the debt, or that the amount that they're seeking is incorrect. Once a trial is completed, judges can do one of two things. They can take it under advisement, meaning they want to consider it more fully before they issue a written ruling, or they can rule from the bench where they'll issue a written ruling right then and there. I've done over 400 trials in debt collection cases, and I can tell you there's no rhyme or reason, at least with the Arizona courts. Some judges prefer to think about it, some prefer to issue the ruling right there. It just kind of depends on their typical procedures. So those are the four main steps of a debt collection trial: filing your answer, disclosure, discovery, the motion for summary judgment, and trial. It's important to note you can also try to settle or resolve the case at any one of those stages, right from the very beginning, right up until trial. If it's something where you have a proposal that you want to present to the plaintiff, you can do that, and you can usually do that without fear of it being used against you. The rules of evidence, typically Rule 408 in most jurisdictions, states that the parties cannot use attempts to resolve the dispute against them. So if you offer them X amount of dollars to get this thing settled, they can't then use that against you in trial and say, hey, judge, they already offered this money. They clearly owe the whole thing. So there's some comfort in being able to do that. And I always say this, going to trial, you're putting the final decision making in the hands of a judge or a jury. You're losing a lot of control by pushing the matter all the way to trial. So if there's a good opportunity to settle, it may not be perfect, but it's something where you can control the terms of it. And trial's all or nothing. You're either going to owe the full amount plus attorney's fees plus costs plus interest, or you're going to owe zero. And so if you're rolling the dice a bit, because I have told people, like I said, doing hundreds of these trials, there's trials that I have had the facts where I should have won, and trials that I've had the facts that I should have lost. So it could be very variable, and they're in the way that the courts approach it, and sometimes it's not very predictable. So hopefully that helps you. If you are dealing with a debt collection lawsuit and you're in the state of Arizona, my information is below. I do free consultations where I can help determine if your case is something that we can help you out with in getting it resolved. I also have my Consumer Warrior University tutorials, templates for many different things like drafting an answer, disclosures, discovery, motions for summary judgment, and even preparing for trial. If you're representing yourself, check those out. Also, check out the link to Solo Suit. Cool company that we partner with on a lot of things where they actually use a lot of technology to be able to put things together to make things a lot more easier to prepare some of these documents. So hopefully that's helpful today. Thanks for watching.